the Deputy Minister of COGTA, Honorable Bapela, for joining us and leading the delegation from the side of the department. This is a meeting of our select committee, and as you are aware, the agenda has been distributed to all the members. We're coming to deal with two specific issues pertaining to the mandates that comes from our provinces, the negotiating mandates in respect of the two bills that are on the table, the one pertaining to the initiation bill as well as the amendments to the Municipal Structures Act. In that sense, I want to really welcome all members present and just note the apologies. Who has apologized for what? Can you just take us through the apologies if there's any member of parliament who has apologized and is not part of this meeting? Fuad? Hello, Fuad?
Chairperson?
Is there any apologies that we are noting? No.
No, Chairperson.
Okay, no problem as such. What we are going to do for the purpose of this meeting, we will firstly obviously record all the members who are present in the meeting. I've not received any apologies from any member for the purpose of this meeting. We are going to receive two specific presentations, and those presentations will pertain to the consolidated reports that comes from our 9 provinces in respect of the negotiation mandates. We'll firstly start with the amendments to the Municipal Structures Act, and thereafter we will go to the initiation bill. In that respect, I'm going to firstly start by, as I indicated, firstly welcoming the team led by the Deputy Minister, Obed Bapela, who's going to firstly start by giving us the political overview, and thereafter we are going to start with the Municipal Structures Act and conclude with the initiation bill. In that respect, for each bill that is going to be on the table, I'm going to allow each member coming from different provinces to table the negotiation mandate as per their own provinces. This committee is very good. It is well represented. All members, all provinces are represented in this committee. We are not going to battle in that respect to facilitate this particular aspect of the mandate. In that sense, let me just start by allowing the Deputy Minister to just have a word to the meeting before we start with the Municipal Structures Act. Over to you, Honorable Deputy Minister.
Thank you, Chairperson of the meeting, Dr. China Dodovo, and all honorable members of the Select Committee. Good afternoon to all. No, thank you very much for the opportunity. I'm not going to be too long. As you said that you are considering mandates that comes from the provinces on 2 pieces of legislation. One obviously being the Municipal Systems Act that has been in the public space for over 5 years now. As you remember that it was tagged as a 75 bill and then went to court, and then the court turned it down to say it should have been a 76. Hence the consultations that had to go to provinces now through the NCOP mechanisms. Finally, we are now compliant to the court as we consider the mandates that indeed it's coming back as a 76 tagged bill. And secondly, obviously, the clauses that were difficult were around the issues of the officials and then the workers in the municipalities as to whether they can stand for a political office or not stand for political office. I hope the mandates will further enhance and help us as we'll be listening to what each province is saying around those sections of the bill. And on the initiation bill, Chair, I think it's a matter that is dealing with the African value system that African communities continues to practice initiation, as you know, as part of the African value system. And then this African value system will have to be protected as the Constitution dictates on us, that we should continue to do so, whilst embracing other cultures and other systems that are part of the South Africa that we are all building, belonging to all who live in it. And as you will know that the colonialism did trounce on some of the cultural values of the African communities. So, and in dealing with the legislation, is really to sanctify all those cultures that they are part of the South Africa that we are building. However, the issue of the safety is now a big issue, that children are dying when they go to initiation. And then also the hijacking of the culture is another that we want to deal with in this legislation. And thirdly is the commercialization of culture that we also want to deal with, so that the people can still go through the passage of boyhood to manhood without them dying, without anybody destroying the cultural value of why kids must go there, and then to instill that element of African values, Ubuntu, and then also to then begin to deal with wrongdoing that is unfortunately happening, whilst allowing culture to be adapting to the social conditions and the evolving conditions that are taking place as part of the development. So, Chair, I think we will then be listening. The department is here led by the DG and some DGs and other DDGs and some other officials. And I hope therefore that and as part of the listening, they'll then take notes on the areas that might need further actioning in the amendments. And then obviously, whatever comes out of these particular processes will then be enabling the legislation to go once more through the state law advisors to say, this is what the mandates are dictating, and then confining ourselves to what the people's wants, because this is the people's legislation. Thank you very much, Chair, and just wishing everybody well in terms of their deliberations. We will be here listening. Thank you very much, Chairperson.
Okay, thank you very much, Honorable Deputy Minister, for your brief words, introductory words. What we are going to do, I'm going to give honorable members a province to just formally table the mandate of each province to the meeting. I'm aware that all provinces, the 9 provinces, have supported this mandate. There is no province that has said no, but it's quite important that we formalize that in respect of the representatives from different provinces who are part of this meeting. Can I start with Eastern Cape? Honorable
Chairperson, the DM Bapela, let me also correct myself. The structures bill, not the systems bill.
Yes.
Yeah. The systems bill is still coming to our way. So here we're dealing with the structures bill, which does not have much except those technical errors that have been pointed out. Thank you very much.
Yes, this is the amendment to the municipal
structures.
Not the bill. The Systems Act is on its way. It's coming.
Yeah, it is on its way.
The appointment of senior managers. This one is in terms of the structures, proposed structures in terms of the Municipal Structures Act. Can I give over to Honorable Nita from the Eastern Cape? Any word? Your province has approved the amendments and has given the NCOP the negotiating mandate. Any word from you? Honorable Nita? If he's not there, can I pass? Honorable Mikalakis from the Free State.
Thank you, Chair. The Free State supports, subject to the amendments as set out in the negotiating mandate. Thank you.
All right, thank you. Honorable Motsamai, can I give you from Gauteng? If you are not there, I pass. I just want to formalize and officialize this. Honorable Mutsamai from Gauteng, I pass. Honorable Sheikh from Limpopo,
Thank you, Honorable Chairperson. Chair, Limpopo has conferred that we negotiate, or the permanent delegate negotiates in favor of the bill, and they've also proposed some amendments. Thank you, Chair.
okay. Honorable Mfayela from KZN,
Yeah, Honorable Chairperson, yes, we should carry on with the negotiation, and we support the bill. The province support the bill. Thank you.
that's wonderful. Can I take either Honorable Zandamela or Honorable Nkosi? Let's welcome the new member of this committee who has replaced Honorable the late Martha Mola to the committee. Any one of you can do it. Honorable Zandamela. Honorable Nkosi from Pumalanga. I move. Honorable Bartlett from the Northern Cape.
Yes, Chair. The Northern Cape is on the bill and the Northern Cape support the bill. Thank you, Chair.
Correct.
Okay.
Thank you very much. Honorable Professor, would you mind doing it on behalf of the Northwest? If she's not there, I'm doing it. Yes, we had good engagements. I was the one who was facilitating and chairing the meeting, and we have adopted and we support the mandate. Honorable Sileku from the Western Cape.
Thank you, Chair. The Western Cape supports, subject to proposed amendments. Thank you, Chair.
Okay. All right. Thank you very much. Can I then give over to the DG of COGTA, Cooperative Governance, or somebody designated from that department to take us through the amendments? Over to you.
Good afternoon, Honorable Chairperson. It's Kevin Naidu. I'm the Executive Manager responsible for municipal governance in the department. I'm joined by a team of colleagues, Chair, Ms. Diale, Ms. Makaza, Mr. Nkeshli, and Mr. Nkaichana from our legal department in COGTA, as well as Mr. Granville Abrahams from the IEC. Honorable Chair, as you'd recall, we've been making this presentation both by the IEC and by the department, mostly because it is a bill that is, based on three pillars: electoral amendments, governance-related amendments, and then amendments of a technical nature. If I can maybe ask the host if I could share the screen, Chair, so I can upload the presentation or the document that we've prepared in this regard.
Yes, host, can you do it very quickly, please? You should have arranged this prior to this meeting as a norm so that we are able to move with speed. But nevertheless, the host, can you share the screen, please, quickly? Yes.
Okay, is my screen viewable?
I mean, this is the main screen. We're waiting for you to flight the presentation.
Okay, is it viewable now, Chairperson?
Not yet. It's the main screen, the dashboard.
Okay, for some reason, I can't seem to share this, Chairperson.
Chairperson,
Hello?
the problem seems to be from the department, not from our side. We've tried to share the document.
How's that?
Yes.
I don't know what do you want us to do. We've all received the copies of the presentation from the department. Okay, let's try it. It was coming all right, but it's going off.
Okay, can you view it now?
No, not yet. I suggest that you take us through the presentation, and this is really unacceptable. It is inconveniencing members of parliament, and it doesn't allow the meeting to flow in the way that it should. These prior technical things must be done before the start of the meeting so that we do not encounter this. I propose in the meantime, take us through the presentation that you have submitted to honorable members, please, without wasting a lot of time.
Okay, my sincerest apologies, Chairperson. So the document is structured such that we have the Eastern Cape first, and the amendments that have been proposed by the legislature chair are electoral in nature. And I'm going to ask Mr. Granville Abrahams to take us through. I'm going to exit and try and re-enter and see if it's going to have any luck in the meantime, Chairperson.
Okay.
Mr. Abrahams?
Thank you, Dr. Naidu. Honorable Chair and honorable members, thank you for this opportunity. If I could read from the document that the members should be having, that we're having difficulty sharing. The first contribution from the Eastern Cape relates to Clause 8.
Yes. This other person, they went out now. I think he's going to come in again now.
Fuad, don't disrupt the meeting, please. Can you proceed, please, Kevin?
Sure. It's Granville Abrahams, Honorable Chair. The proposal from the Eastern Cape is that a councillor who is removed from office by the MEC for local government in the province, in terms of section 16.7b of the Code of Conduct for Councillors, as contained in Schedule 7, that councillor may not stand as a candidate for an election for any municipal council for a minimum of 2 years from the date of such removal, and which period may be increased depending on the gravity of the contravention. Now, let's just revisit the proposal first of all. The proposal that we have in the bill is 2 years, and that's an absolute period. The amendment from the Eastern Cape suggests a minimum of 2 years and that period may also be increased depending on the gravity. The difficulty, Honorable Chair and honorable members, is by effecting a punishment or a restriction on candidates through a term, as it's phrased here, which period may be increased depending on the gravity of the contravention of the code. We find that this is open to different interpretations. We're now going to have 9 MSCs, and one could have different interpretations and applications, therefore, across provinces, as well as, when it comes to applying this to different councillors from different parties or political persuasions. They may feel aggrieved that because they are from one party, now it's being more severe on them. We therefore say that it's not advisable to incorporate this additional increase. I also want to draw members' attention to the fact that if a contravention is so serious that it is deemed for the limitation to be much larger than 2 years, I would assume that here we're talking about serious matters that would not only be in contravention of the code, but in all possibility also be possibly criminal matters. Now, the reason why I raise this is because this issue regarding being found guilty of a crime and sentenced to prison and resulting in an exclusion of members is dealt with in the Constitution. So if the gravity of the contravention is more serious, I would hope that it gets caught up in the criminal court and that there is a sentence. And in this case, the Constitution would then say such a person would not be eligible to stand for office if his sentence was more than 12 months without the option of a fine, and he would then have to wait for 5 years after the completion of his sentence. So we feel that any matter that is more serious, that it should be dealt with in terms of the Constitution. The proposed amendment, therefore, is not supported, as it could bring about different interpretations, Honourable Chair. If I can move on, then the next contribution from the Eastern Cape is that clause 11 of the bill, which refers to section 6, says that the MEC for local government in a province may not call a by-election in terms of subsection 1 if the next election of all municipal councils must be held within, the proposal is now 6 months. Now, Honourable Chair, the contribution from the Eastern Cape in this regard does not affect a proposed amendment. The amendment was not to change, or let's rather put it this way, the intention of the amendment was to extend a ward by-election from 6 months to 9 months, because in the currently the legislation determines that in a dissolved council that be 9 months. I thought I'd just point out that. Now, let's address the challenge that this presents. Members will all be aware of the fact that, first of all, that we are now busy with the redemarcation of wards. The MDB will be handing over the final ward set to us, the IEC, by the end of November. Then we need to make work of that to prepare for the election. And part of that is to ensure that voters who are now outside of the boundary, that we realign them through a project of what we call targeted registration to ensure that they are in the correct new ward. By-elections are held in terms of the old wards. So you could potentially have a situation after we have now re-registered you in a new ward, that a by-election comes up in the old ward and you would not be on that voters roll. Alternatively, it creates the dilemma for the IEC now to manage and have two data sets of ward boundaries, which is rather confusing to voters and also a bit of a challenge to us. The second point is that members will probably all be acquainted with the Tlokwe judgment and the Constitutional Court matter, the Mshlope matter that followed, which highlighted the issue of addresses. Since the Tlokwe matter, or the Mshlope Concord matter, the Electoral Commission has used basically all of the 90 days that the Act requires for a vacancy to be filled. In the past, we were able to do this much faster and expeditiously when the issue of addresses was not in being contested. So, even if we say 9 months, we will not have a councillor appointed within 6 months. So a councillor will only be elected for 6 months. If we say 6 months as is proposed by the Eastern Cape, then a councillor will only be there for a maximum of 3 months. Now, this filling of vacancies only pertains to wards. The reason why it does not pertain to proportional councillors is because the proportional councillors work on a list, and it's easy to amend a list and also for the chief electoral officer then just to determine the person at the top of the list elected. So as in the past, we do not foresee, and I think some of the arguments when we were at the hearings was that a ward may end up being without a councillor for an extended period of time. I think that I've sufficiently expressed that because of the fact that we will be using the full 90 days, the 6 months is not really going to make much of a difference. And there's also the challenge of working with 2 ward sets. So we still propose, we do not support the proposed amendment. We're still asking, first of all, that we retain, as the law currently says, for a dissolved council, we leave that at 9 months. And also then for an individual ward, that we align that to dissolved councils and therefore say that we call for a cessation of all by-elections 9 months, vacancies that occur 9 months before the election. If I could throw in a third option to the members, I also know, because I engage with politicians on a regular basis in our national PLC, I know that Parliament closes early so that the members can go and campaign and open their constituency offices, etc. And the focus is very much on the general election. So those are the arguments there in favor of not supporting those amendments. Dr. Naidu, I think the next one is for you.
Okay, thank you, Mr. Abrahams. Chair, we're actually on page 2 still. If the operator could please get there. Okay, so page 2 actually starts with the negotiating mandates from the Free State Province. And in the first and second instances, or in fact, the submission made by the province is very much aligned to the submission that was made to the Portfolio Committee at the time that the bill was introduced in Parliament. So page 2 will show you that the first proposal around the retaining of clause 12.4 and 16.3 was actually dealt with in the B bill, where we did not delete those proposals as it had come through in the A bill. The same would go for the clause 14 proposal, where the province had opposed the amendment of section 29 and had proposed that we have a formulation dealing with the calling of meetings in the absence of the speaker or when the municipal manager refuses to do so. So there is no real amendment that is required in respect of the B bill. Clause 17, the proposed amendment deals with the functions of speakers, and there's essentially 3 proposals that were made by the province. The first 2 are flighted on the slide at the bottom of the page there. And we believe that this was also dealt with in the Portfolio Committee as well. If you can go down the slide, down the screen. Okay, so I've dealt with that clause. It has been provided for in the B bill, so there's no amendment that's required. Clause 17, which deals here, it deals with the functions of speakers. And the proposal 1, in relation to the effectiveness and functionality of ward committees, is provided for in the bill that we have before us. The proposal that speakers must ensure the performance of ward councillors and ward committees. We believe that the first part of the proposal, where the speaker must ensure performance of ward councillors, would be actually something quite difficult for the speaker to take on, to be difficult to manage, and we therefore believe that it would be easier for the speaker to in fact ensure performance of ward committees and not over ward councillors. And we believe that that second part of the proposal, performance of the ward committees, is also provided for in the one above. The third proposal around the ensuring by speakers around the meaningful participation of traditional leaders, as indicated on the right-hand side, the matter is being dealt with through the Section 81 of the Traditional Leadership and Khoisan Leadership Act, which is presently before the President for consideration. Having said that, we believe that there is the proposed amendment is not supported. The next proposal on clause 18, where there should be the more than 40 councillors deleted, that too has been effected in the B version of the bill. So there is no required amendment. Clause 19, dealing with the amendment of section 20 of the Act, the composition of executive committees, and the proposal is that the determination or the identification of members that should make up the executive committee should be done through an authorized representative. It is a proposal that we believe would also assist in ensuring a smooth operating council when this process does happen. So we actually support that. And at the end of the document, we come through a proposed amendment to be effected into the bill. Clause 22, which deals with the establishment of committees. The submission by the provincial legislature says that there should be a deletion of the reference to the minister. This was actually also effected in the B version of the bill that we have before us. So there is no required amendment. Clause 23 deals with the establishment of impacts. And the proposal from the province was that they support the proposed amendments, but they also suggest that the nature, stature, and the authority of impact should be strongly similar to the SCOPAs at both the national and the provincial legislatures. And we believe that, you know, the provisions in the bill presently as it stands does provide for a municipal council to do so, especially when determining the functions of the committee in terms of section 79A3, which we've now provided in the bill. So the proposed amendment is not supported. The next province relates to the inputs from the Gauteng provincial legislatures. And the first proposal was that the committee in the COGTA portfolio committee recommends that the department should ensure that CDWs are regulated and properly and efficiently so. Our response is that CDWs are public servants appointed in terms of the Public Service Act, and that this proposal is already addressed as part of the Public Service Act regulations, and therefore the proposed amendment is not supported. The province also indicated that the Act needs to provide a mandatory mechanism for the replacement of ward committee members who have resigned, are not fulfilling their mandates, or otherwise unable or unwilling to continue, and that a better and more streamlined complaints procedure against ward and PR councillors need to be put in place to be adjudicated upon by an independent body like the Ombudsman. And then the province goes on to also say that the executive maze, a mechanism needs to be put in place where the Ombudsman is appointed by council and can be removed by council, and who has the authority to investigate complaints against MECs and even the mayor, etc. And that there should be a power to pass a motion of no confidence in the ward councillor of a majority of the ward committees, which must trigger a mandatory investigation by the speaker, etc. The response from the department is that section 76 of the Principal Act on ward vacancies, which relates to ward committees, already provides for the replacement of members as published in the guidelines of 2005, and that section 74 of the Act provides for metro or local municipalities to also delegate duties and powers to ward committees in line with section 59 of the Systems Act. That said, Chairperson, the proposed amendment is not supported. The next proposal from the province was that section 6 needs to be amended to provide for civic organization members to be elected in a municipality, to control this issue of nepotism, bribery of jobs, and all submitted CVs to be treated equally. Clause 6 deals with the establishment of municipalities and more specifically around district management areas. So the proposal is actually misplaced, and therefore the proposed amendment is not supported. The province indicated that clause 10 needs to be amended so that civic organizations can elect members to oversee if the accounts are accurate for each household. There are many complaints of how our communities are billed by the municipalities, and municipality staff are alleged to be able to delete or amend their relatives' bill. We could not find any relevance for this specific provision, and we've indicated that the proposed amendment is not supported. Clause 11 can be amended also, whereby the member of a civic organization can be elected from each region and be able to table issues that are a burden from our communities. Section 21 of the Structures Act provides for qualification for a councillor, and it indicates that any citizen who is qualified to vote is also eligible to be elected as a councillor, and therefore, the proposed amendment by the province is not supported. The KwaZulu-Natal province indicated that they support the provisions in the bill and that they had not made any further amendments. The next province submission, Limpopo, their submission related to amendments of an electoral nature, and I'm going to ask Mr. Abrahams to take us through that. Mr. Abrahams?
Thank you.
Can I beg your indulgence as you present? My battery is failing me because I've had a lot of meetings today. I'm trying to charge it. In case that I become muted or I'm not there, Honorable Sheikh will proceed with the chairing of the meeting up until I sort this matter out. You can proceed. Thank you.
Thank you, Dr. Naidu. Honorable Chair and honorable members, the first input from...
Just a minute. For a procedural, can I then support what Honorable Dodov is saying so that there's a mover and seconder for the chairing of the meeting? Thank you.
Yes, I think there's no problem. I'm still in a meeting, but I'm saying my battery is failing me, and I'm finding a way of charging it, and there's load shedding here where I am in the villages. I'm trying to sort it out. I was just saying in case that I go down, Honorable Sheikh will proceed. It's okay.
I support.
Okay, thank you very much. You can proceed.
Thanks, Honorable Chair. The first contribution from the Limpopo province, it is tagged and reference to section 25, and I'll give more clarity on that, the reason why I'm highlighting that. But the province says that it was noted at times that the by-election to replace a deceased councillor are often delayed by late submission of death certificates as a supporting declaration by deceased family as a result of 14 days waiting period lapses. I just want to put on the record, Honorable Chair and members, that by-elections in terms of law must take place within 90 days from the date of vacancy. And the IEC, who is responsible for administering by-elections, is not aware of a by-elections that was delayed as a result of a death notification. We've had very few, a handful of cases whereby election did not take place within 90 days. And for those, we went to court and asked court for an extension, but it had absolutely nothing to do or relating to the notification. But allow me to clarify. I think that currently in the legislation, the legislation deals with ward councillors and PR councillors separately. For PR councillors, there is a duty on the municipal manager to inform the IEC, currently only the IEC, within 7 days And what we have found is that 7 days is a bit too tight. So the proposal that we put in the legislation is, first of all, for PR councillors to extend that to 14 days, and for ward councillors, just to align it to PR councillors. At the moment, there is no time frame for the municipal manager to inform the IEC, even though there is a time frame for the municipal manager to proclaim a by-election. But we are also moving beyond that, where in the bill we are asking MECs for the province to proclaim the elections instead of municipal managers. So the concern that is noted by the province is actually dealt with in extending the period currently in the legislation for PR councillors to 14, and then also to create a 14-day period which currently does not exist. So I think that we are supporting the bill. Actually supports the concerns that the province is raising. Therefore, the proposed subsequent amendment that they are making is not supported by us as sponsoring that. Then there's no, I think that is that one, the death certificate. Then the bill must provide for consequences against a municipal manager who fails to inform the MEC about a ward vacancy within the municipality which exists as a result of deceased councillors. I would think that this is not only applicable to deceased councils, but probably to all councillors. The failure to inform the MEC about a vacancy more often happens with PR councillors, because when there is a ward councillor vacancy, you'll find that there are a lot of other, if I could call it, other interested parties, such as other political parties who's obviously looking forward to contest an election for that seat. But for a PR councillor, the seat remains within the party. We have no objection to the proposal. There's a recent judgment which involved a councillor in one of the municipalities in Mpumalanga, a certain Mr. Councillor in Paslele. And the municipal manager did not act timeously to inform the IEC. And as a result of that, the IEC also did not act within its time frame. And even though the matter is being appealed, it's important to note that the judge was very strong remarks and said basically that the municipal manager was in dereliction of duty. Therefore, a municipal manager who fails to inform the IEC about a ward vacancy within the municipality would be subject to a disciplinary action in terms of the disciplinary code and also procedures in this regulations. And the comment there is that we feel that that is already provided for within the bill, and it is therefore not supported as an additional amendment. Then I think the following one we have already dealt with, whereby the province says the bill provides for 6 months for ordinary by-elections for a ward vacancy and 9 months for cessation of by-elections, which will apply to a dissolved council. It says that the bill should reduce the 9 months to 6 months so that the surrounding communities do not suffer service delivery, as there would virtually be no council operating in that municipality. I have already, and in the interest of time, Honorable Chair, I'm going to refer you to the to the response that I gave earlier under the Eastern Cape, who had similar proposal that was made in this regard. Dr. Naidu, I think you're up next.
Yes,
Can I
thank
also,
you.
in the meantime, request you not to over-belabor or emphasize the points as they are captured without taking the gist of it? We received the reports and we can follow and see what is happening. And in the interest of time, can we just expedite it because we have a long way to go in terms of this meeting, please. Mr. Naidu, over to you.
Thank you, Honorable Chairperson. So the next proposal from the province indicated that the position of deputy mayor should be for bigger municipalities. And we're saying as our response that the provision or the designation of deputy mayors is actually provided for by the MEC for local government in the provinces, and the MEC indicates this through a Section 12 notice that you would issue at, prior to the election of municipalities. So the proposed amendment is not supported. The next proposal deals with the participation of traditional leaders. And as indicated earlier, the matter is a matter that has been referred to the Department of Traditional Affairs for consideration. The Mpumalanga province and the Northern Cape province have supported the bill, but have not made any proposals as such. The Northwest province, two proposals. The first indicates that a councillor who has committed an offence should be advised to step aside. And we're saying that if the intention of the proposal is to indeed achieve that, then that would have to be a party policy matter, and therefore the proposed amendment is not supported. The next proposal around the speaker or acting speaker when they refuse to call a meeting, and the confusion around some of the wording there. We've accepted the proposal, Chairperson, and the proposed rewording is at the end of this table. The next input is from the Western Cape Provincial Legislature. And in the first general comment that they make, they raised the issue around the number of councillors, the 15 in the A list being reduced to the 10 in the B list. And we believe that this is a matter of a drafting nature, and I think that the lawyers would respond to that. The next proposal is supported, Chairperson, where it is asked for an alignment of the migration of the Code of Conduct from the Systems Act to the Structures Act. The following clause proposal is also supported, Chairperson, by the inclusion of by the Electoral Commission after the word results in the definition section of the bill. The next clause deals with the definition of whip in the bill up front. And while we say that it is not supported, we say so because the definition of whip has been included in Schedule 3 of the bill, or for inclusion Schedule 3 of the Act, which deals with the definitions of municipal office bearers. But we believe also that this is a matter of a drafting nature, and that the legal team may want to respond to that as well. The next proposals were around providing definitions for ordinary meeting, special meeting, urgent meeting, as we have now indicated in the bill. And we're saying that the actual definition of these various types of meetings are provided for in the rules of order for councils. And by doing so, it also allows municipalities for more flexibility and for councils to actually adapt to local conditions if it is done through the rules of order rather than through the primary legislation. In fact, in terms of Section 14 of the Systems Act, the minister can also make standard draft bylaws, which could also include draft bylaws for rules and orders for municipalities. The next clause, Chairperson, deals with the plenary type of municipality. And in the submission from the province, they've indicated that bold statements have been made around why this type of municipality should be done away with. This matter was also ventilated in the portfolio committee that considered the bill when it was in the committee. And as part of dealing with the concerns that the province had raised, we've highlighted now further matters around why the plenary type of municipality should actually not be an option for provinces any longer. So the clarity that was required has now been provided in the submission to the select committee. What we have on the right-hand side, Honorable Chairperson and members, is the 25 municipalities in the country that have the plenary type of municipalities. And suffice to say, Chairperson, this type was not raised by the municipalities that have been affected. The clause 4.5 proposals are also related to the plenary type, and for the same reasons as advanced, the proposed amendment is not supported. The next clause deals with the formulae for the number of councillors, and we're saying that in the proposal that we have in the bill, that any request for deviation must be done in consultation with the Minister of COGTA. And we're saying this basically for two reasons: to see that provinces actually satisfy Section 23 of the Act, in that they are deviating by the number that the formula generates to satisfy those provisions there. But secondly, also for the department to use it as a verification process as it, works closely with the demarcation board and the IEC once this matter is finalized, and which actually triggers the ward delimitation process. Clauses 9B and 10C and clause 12A deals with in the first instance, the clarity around the declaration of elected, and we're saying that while the province indicates that this is superfluous, we believe that it is something that is necessary as it provides clarity, and therefore the proposed amendment is not supported. The next clause deals with the code of conduct for councillors, and it provides a proposal that we need to align it in terms of the deletion thereof in the Systems Act. And we're saying that in the bill that we have before us, clause 31 adequately deals with the migration of the code of conduct from the Systems Act to the Structures Act. The next clause or comment on Section 29 of the Structures Act deals with clarity being required on what majority of councillors mean. And we believe that the proposal that we have before us, and that the majority that is referred to in Section 29(1) and Section 30 actually is clear enough in that it refers to the number of councillors as determined by the MEC in the Section 12 notice. And more specifically in that Section 30 is titled Quorums and Decisions. And by virtue of that, the quorum for a meeting should actually be simpler to understand. Clause 13 deals with the the provision that relates to the calling of meetings by a person designated by the MEC, and they believe that to provide clarity, there should be a reformulation, and we believe that we actually support the proposal that is being made by the province. The subsequent and similar proposal is being made around the calling of a special meeting, and we believe that the rules of order would actually provide for this in instances where a meeting is not called for. Clause 14 deals with ordinary, special, and urgent meetings, and we believe that while a definition is called for this, we believe that the rules of order actually provides for this in detail. We had a scan or did some research on some of the metros, and this is adequately, Honorable Chairperson, provided for in their rules of order. For example, an ordinary meeting, they classify as meetings that are held quarterly. Municipalities will call a special meeting to deal specifically with the annual budget or bylaws, and they would give a 72 hours to 7 days time frame for that and the conditions, and then urgent meetings are classified or dealt with on a 24 hours notice, and instances when such meetings should be called. Clause 16 deals with the plenary type of municipality, and this specific proposal is also not supported for the reasons advanced previously. Clause 23, which deals with now the new section 79A in the bill, which relates to the establishment of oversight committees. And there is a belief that it is not known when the envisaged report and review should be referred to in the provisions in the section. And we're saying that for clarity purposes, we have made reference, I think at least on twice, to the MFMA in the provision, and we're saying that this is not unique. And there are instances cited where, a section would be cited for clarity purposes. But Chairperson, what we have picked up in this section as well is a drafting challenge. And it is something that we would need to fix in terms of section 79.583C, where there's been a wording mix-up, and something that I will come to at the end of the presentation as we make our proposals. Clause 26 deals with the plenary type of municipality. And for the reasons advanced already, Chairperson, the proposal is not supported. The next clause deals with item 5.2 of the Code of Conduct. And it says that the words "must be removed from office as a councillor" should be changed to read "may." And we're saying that the "must" is in the original text of the Code of Conduct, and that it is something that we want to retain. But further than that, Chairperson, that very specific item goes on to say that when a councillor is removed, it must be done in terms of a uniform standing procedure and in accordance with the rules of natural justice. So we believe that there is, in inverted commas, some form of protection when a councillor is removed from office. The next item 16 deals with the investigations provided for in the Code of Conduct. And here too we say that the provisions that are in the Code of Conduct as we have it presently is largely similar to what is in the original text. But that said, we do accept the proposal that the inclusion of the words "by the MEC" be included in the item 16.4b, So that specific part of the proposal is indeed supported. The next clause, and this would be the last proposal from the province, deals with item 17.7. And the province indicates that we should have some alignment with the Promotion of Administrative Justice Act. It is something that we've accepted, and you know, we've indicated that we will include the words promotion of administrative justice after, or replace natural justice with those words. Chairperson, the next part of the presentation deals with the proposed amendments from the provincial legislatures themselves. And if we look at the amendments here now, it's very specific in terms of, you know, pointing to the exact page, the line in the page, and the insertion of the word electoral by the Electoral Commission after the word election. The proposal then to give effect on page 5 from the Western Cape on good cause shown designated person to, so to remove those words to provide clarity and to remove the confusion. To give effect to the proposals from the Free State Province Chairperson, we've indicated that on page 8 in line 23, to insert the words through an authorized representative, but to also include it further down in the provision for alignment. The next item 16 and the proposal from the Western Cape Province on page 17, line 40, to insert those words as indicated there. And then lastly, from the province, from the Western Cape, the matter around PAJA to replace with the rules of natural justice. And then also, as part of the Western Cape proposal as well, to ensure that, you know, code of conduct in the Structures Act now is properly referenced. So through the new amendments that we're looking at, Chairperson, we're looking at now in the bill itself on page 20, on page 1, to insert the definition authorized representative, which would mean a person as defined in the Local Government Municipal Electoral Act, and the responsibility for that person to determine the representative that will make up the executive committee in that specific type of municipality. On clause 7, this is actually a new proposal, Chairperson, that would probably need ventilation. And we're saying that where the qualification is provided for when deviating in instances of local and metropolitan municipalities in excess of 20,000 kilometers, you know, that the threshold of 35 be removed, and that, you know, such municipalities, local municipalities, be allowed to deviate by the 20% that we have in the bill. The next proposal is on page 5 in line 54 to delete the words of the municipality after the word manager. On clause 27, it is also of a technical nature to replace the word seats with the word votes. It was actually an oversight in the drafting. Clause 30 on the code of conduct, to revert to what is in the original provision in the code of conduct. We believe that the removal of the commas would be in order to give effect to what the intention is in that specific item. To replace chairperson with speaker, this is a technical correction and carries no real change in the meaning. The next proposals, Honorable Chairperson, deals with the aligning of the word determine, and the removal of the word election in each of those specific instances. These are also technical corrections only and carry no real change in the meaning. And that goes up until the heading, the heading in red there that says the following new amendments are proposed, which deals with the date of effect of certain provisions. And this is our proposed transitional measures, Honorable Chair, which we have not provided for in the bill. And we're saying that, the changes in the number of councillors, which may be occasioned by the deviation of 20% in your large municipalities, that should only take effect from the following local government election, which would be in 2026. You'd know that the numbers for the next elections next year have been determined already and wards already delimited. And then the change in the type of municipalities. So those 25 plenary type municipalities, which would no longer be, that would not happen, in the middle of a term, but at the commencement of the new term of local government after the next election. And then lastly, Chairperson, the matter I indicated earlier around the establishment of the oversight committees in section 79, the new 79A, and we're proposing that the 79A3C be reworded to provide clarity as the present formulation provides some confusion. So thank you very much, Honorable Chairperson and members. That is the submission on the municipal structures and the negotiating mandates that we've received as a department. Thank you.
Thank you very much for the consolidated briefing, which was quite detailed, but really necessary because these are the views emanating from different provinces. What is it that they propose in the amendment to the Municipal Structures Act? I think it's quite important to do that because the provinces must have a very strong voice in terms of what is happening at municipal level, more especially how structures must be formed. Provinces play an important role in terms of supporting municipalities, strengthening their capacities, as well as monitoring the performance of municipalities. And it's quite important that we hear the inputs and contributions from provinces. Now I'm going to give over to the legal advisor from Parliament to also give a view in terms of, or analysis in terms of the submissions from different provinces. Over to you, legal advisor from Parliament.
Thank you, Chairperson. My name is Fatima Ibrahim. Greetings to all members. Chair, I've been fortunate enough to have had numerous engagements with the department in respect of their views to the proposals made in the mandates, and we've managed to find each other and we've agreed on everything. So I share their views. There's just one or two minor things that I wanted to add, Chair. In terms of the proposed amendments, Chair, there's one or two further consequential amendments that I would like to see being inserted. One is just a definition of what the Code of Conduct is. That definition at present appears in the Systems Act. And of course, now that we're incorporating the code into the Structures Act, we would need to also then incorporate that definition, Chair. And also just a general clause to talking about the applicability of that code and to say that it applies to all councillors. So that's just to complete the transition of the of that schedule from the one act to the other. Then, Chair, I have a concern about the new proposal in terms of clause 7, which is the determination of the number of councillors. You'll recall that Mr. Naidu has proposed that the part of the clause that deals with the number of councillors in terms of the formula, the 35 councillors, that portion be deleted. And my concern there, Chair, was that this was not part of the amendment bill. There are no negotiating mandates that speak to that specific issue. So this is a new issue, Chair. So I do have some reservations about us now extending the scope and looking at that. As far as the rest is concerned, Chair, they are all technical issues, and I'm in agreement with the proposals from the department. Thank you, Chair.
All right, thank you very much for your contribution. I'm going to open the floor for discussions, comments, questions from honorable members. I don't know how to control this. I'm going to just request honorable members who want to have a bite to just raise their vote to indicate to me so that I line them up. Who wants to speak to the presentation? Any honorable member who wants to make a comment? Remember what we are going to do after this session, honorable members. We are going to call another meeting where we are going to deliberate as Parliament, as well as considering what is called the C list from the department before we adopt what has been presented before us. But for now, I want to get some few hands from members who want to comment on the presentations.
Yes,
Is that Honorable Sheikh?
Yes, thank you, Chairperson.
Yes.
Chair, I think in terms of the, well, we should perhaps thank both the department, the IEC, as well as the legal advisor in terms of the submissions that they made. I think from my side, there has been a lot of clarification made in terms of the issues that have been raised, and it covers some of the comments that come from provinces. There are also other aspects where it's indicated that issues are covered in other bills or in a policy framework or other, whether the issues covered in the bill itself or in other policy frameworks or in other legislation and regulations. And I think I'm quite comfortable with the explanations that also come forth. Chair, I think the amendments that they propose, I'm in support of that, but I would also support the suggestion by the legal advisor, especially in terms of looking into the definition of the code of conduct and the general clause of the application of the code, that perhaps as they are busy looking at the C list, that the legal teams come to some kind of agreement or proposal that goes into the C list. Chair, however, in terms of clause 7, determination of the number of councillors, maybe, Chair, we can just be reminded again about clause 7, Chair, and then perhaps comment on that. Thank you, Chair.
Thank you very much, Honorable Sheikh. Any other contribution? Are you covered? Are you satisfied, honorable members? I don't see any hand. Okay. Over to you.
I did raise my hand, Chairperson. I thought you were seeing it on the screen.
Oh no, I don't see. Okay, I know you, Deputy Minister.
Oh, okay. No, Chair. I was just saying that the mandate that comes from provinces on section 18, on clause 17, section 18, which is the number 3 on the proposals of the mandates. It does speak about, in addition, proposes the following functions to be assigned to speakers. Roman figure 1 must ensure the effectiveness and functionability of vote committees. Roman figure 2 must ensure the performance of vote councillors and vote committees. And Roman figure 3 must ensure the meaningful participation of traditional leaders in council. And then obviously there is a narrative when you go to the next column in line with the proposals. And the department has written there in red, proposed amendment is not supported. So I just wanted to explain in particular the role of the traditional leaders that the provinces so wish that it should be strengthened. The proposal not supported is not because they are rejecting the strengthening of the role and participation of traditional leaders. It is just saying that the TKLB or the Act as is now, on Section 81, it is as comprehensive that once that becomes law, automatically it will then replace in total Section 81 of the Municipal Structures Act. So therefore, it's quite sufficient that it will be able to deal with that Section 81 to give more meaningful role for traditional leaders so that the complaints that the provinces experiences about lack of participation or no participation, it will then be done away with, and traditional leaders will be more emboldened to then know that their role is now being well recognized and they are participating and we are together in the building of the new South Africa. So therefore, that replacement, let's wait until the law is in place and it will come back to Parliament to say Section 81 now has to relate to the Traditional Leadership Act section that then deals with the role of the traditional leaders. So it is in that context that I just wanted to explain so that later as a co-select committee, you are going clause by clause, you will then have to have this context and explanation. Thank you very much, Chair. Thanks.
All right, thank you very much, Honorable Deputy Minister. Any comments from the department, from the points that were raised by Honorable Sheikh? Just briefly, if there's any.
Yeah, maybe very briefly, Chairperson.
Mr. Dr. Naidu, are you?
Yes. Yes, Honorable Chair. Yeah, so it was just a matter around clause 7 and the proposed, removal of the threshold of 35. Now, in previous presentations, we've indicated that there's 10 municipalities in the country that fall in the category of greater than 10,000 kilometers. And we're saying that, in consideration is that if the cap of 35 is there would be a stage where, these 10 municipalities would sort of not, and let me use in inverted commas, benefit from the 20% deviation that is being proposed. But Chairperson, I think I'd leave it there, and it's something that we would want to take further with the legal advisor in terms of, whether it is acceptable or not in terms of, the rules of Parliament and et cetera, et cetera. Thank you very much, Chairperson.
Honorable Didovu. Okay, I think we've lost Honorable Didovu. Well, thank you for that comment. And I think as you concluded, you indicated that it's an issue that you would look at together with the legal team. And I think it's a matter that we can also further consider when we deal with the C list of amendments. I think given that, is there any other member that would want to raise any issue on this bill before we close? Okay, I don't see any hands. Perhaps maybe we can then close it on that note. Honorable members, in the next meeting that we convene, we will then look at the C list of amendments as it relates to the Municipal Structures Amendment Bill. I think, honorable members, let me just thank the department representatives and the IEC for the presentation. I think we'll now go on to the second item on the agenda, which is, my apologies, which is the which is the Customary Initiation Bill. On members, I think we'll also go through a process in terms of formalizing the positions in the negotiating mandates that we received from provinces. I would perhaps then ask if the representatives from the various provinces are present. I understand that Honorable Nita had to attend to another meeting. Is there any other representative from the Eastern Cape? If not, I think that we'll move on to the Free State. Honorable Mikolakis.
Thank you, Chair. We support subject to the proposals made in the negotiating mandate. Thanks.
Okay, Mpumalanga. Honorable Nkosi or Honorable Zandamela? Okay, free Gauteng. Honorable Motsamai. Honorable Nkosi. Honorable Motsamai. Okay,
Thanks,
actually,
we support. Thanks, Chairperson, we support.
Thank you, Honorable Motsamai. That's from Gauteng. From Limpopo as well, the province support of the bill. Yes.
Chair from Limpopo, we support.
Thank you, Honorable Apiri. Yes, ma'am.
Yeah, Chairperson Mpumalanga, we support. Thank you.
Thank you. Is that Honorable Nkosi? Thank you very much. Northwest, Honorable Dodowi is not present.
Honorable Chair, Northwest supports the bill.
Thank you. KZN.
KZN, CISA.
Thank you, Rafael. The East, I see Honorable Matiwani was, yes, thank you.
Eastern Cape supports the bill, Honorable Chair.
Thank you very much from the Eastern Cape. Western Cape.
Chair, Western Cape support with proposed amendments. Thank you very much.
Okay, thank you. I think I missed the province.
You must Northern Cape, Chair.
Northern Cape, yes.
You must Northern Cape.
Northern Cape, Honorable.
Yeah, we support, Chair. The Northern Cape support the bill.
Thank you, honorable members. All 9 provinces are in support of the bill or favor to negotiate in support of the bill. I think given that, honorable members, I'll then request the department to take us through the proposed amendments that have come through by the various provinces. I'm not sure who's doing that presentation, but if you could please also identify when you do that presentation.
Chairperson. Chairperson?
Yes.
Zandamela is struggling to come in. We checked it off. I don't know how.
Okay, can the meeting host attend to that, please? Let me pass, Deputy Minister. He's the Deputy Minister for Traditional Affairs with us. Moss?
Yes. Yes, the Deputy Minister is here, Chair.
Chairperson.
Okay, Deputy Minister, would you want to open or say anything? Or can I go directly into the presentation from the officials? Okay, let's get on with the presentation then.
Honorable Chairperson,
Yes.
I was waiting for my Director General to maybe introduce the topic, Mr. Tipofa.
Okay, Mr. Dipofa. Over to you, Mr. Dipofa. Mr. Bester, I don't know what is happening with Mr. Dipofa. Mr. Dipofa? Okay, I see he's the co-host. Mr. Bester, perhaps you can continue, please. I think.
Thank you, Honorable Chair.
Thanks.
Honorable Chairperson, Honorable Members, Deputy Minister, DGs, colleagues, thank you for this.
Okay, Bester, 1 minute. Mr. Dipofa, do you want to say something? We can't hear you. We still can't hear you. Mr. Dipofa, we cannot hear you, and I don't think you're hearing us either. Okay, Mr. Bester, please continue.
Thank you, Honorable Chair. Yes, in this case, all provinces, as they've indicated, the permanent delegates indicated that they are supporting the bill. Our document, which is on screen, deals with the provinces in alphabetical order. And you may find that here and there we will say that the matter that was raised by a particular province is dealt with elsewhere. It is just because we have received some of the mandates before others. So we didn't duplicate and repeat some of the processes. You will see as we go through the document quickly that we are supporting quite a large number of the proposed amendments because as a department, we believe that it will improve the bill. Some of the proposals made by provinces are purely comments and some are already covered in the bill. We will point it out as we go through the document. And then we also appreciate the fact that some of the provinces drafted proposed amendments rather than just making comments. That was extremely helpful in our case. And then lastly, before I go into the content of the document, Honorable Chair, we have already drafted also the C list of the bill based on what we are supporting from the department side, but obviously it is subject to what the committee will decide eventually. So if I can start then with the Eastern Cape, Chair. The Eastern Cape is proposing, firstly, I will refer to the items, which is the item number right on the left. So in item 1, Eastern Cape is proposing that caregivers, traditional surgeons, and traditional medical practitioners that are involved in initiation should have at least 10 years period after they've graduated from initiation, before they may get involved in initiation. We are supporting that proposal. We think it's a very good proposal. It also was proposed by another province. And then in the right-hand column, we are indicating, we are giving honorable members the clause as it currently reads, which is clause 2.4. And then we are proposing to accommodate this proposal from the province. We are proposing that we split up the existing clause, keeping the first part, taking the proviso that is currently there, make it a B part, and then bring in the C part, which will deal then with the requirement that these people must have, there must be a period of at least 10 years after they graduated before they get involved in initiation. So we support this proposal. The second proposal, item 2, the province says that there may be no discrimination against people with disabilities and or sexual orientation. We are also supporting this particular proposal, but the inputs that we have, the actual amendment, we will find under the Western Cape inputs where they came up with a similar proposal because Western Cape was received before Eastern Cape, so we dealt with it there. Then, Chair, item 3. Here, the province is proposing that only, or that in the case of a person who's older than 18 years, that person must get consent from his or her parents to attend an initiation school. Now, in this case, the department is not supporting this particular proposal. The reason is that the Children's Act defines a child as a person who is under the age of 18. In other words, a person who is 18 or older is regarded as an adult, has reached age of majority, and therefore does not need the consent of his or her parents. Then, Honourable Chair, if we go to the Free State. The Free State, that's item 4. The Free State says that the definition of circumcision should be reconsidered in consultation with the houses of traditional leadership. The Free State has not drafted a particular amendment to this clause, but it should be noted that this bill, the whole bill, including the definitions, then obviously, were consulted with the National House of Traditional Leaders and many other houses of traditional leaders, all the provincial houses, on many occasions, and the bill was supported by all the houses. It's also important to note that the definition is aligned with a similar definition in the Children's Act as far as it relates to female circumcision. And then the part dealing with male circumcision simply states what exactly is part of male circumcision. In fact, Honourable Chair, it's important to note that the whole bill, and I know this was pointed out to the Select Committee during the initial briefing on the bill earlier this year, the whole bill is aligned with the Children's Act, and we cannot put in anything that's contradictory to the Children's Act. So that particular amendment we do not support. The next proposal, or rather comment from the province, item 5, says that there should be clarity between the words circumcision and initiation. Now, I've quoted for honourable members' benefit the two definitions in the right-hand column as they appear in the bill. And there's a very clear distinction between these two definitions. We believe there is no uncertainty as to what each of them mean, and there is no need then to provide any further clarity on those two definitions. Chair, the next one, item 6. Here the province refers to two issues. The first one is that instead of the age requirement of 40 years for principals, traditional, that they must be at least 40 years old, principals, caregivers, traditional surgeons, that it should only be the requirement of 10 years after having undergone initiation. Now, the one about the 10 years we've dealt with earlier under the Eastern Cape, and we are supporting that. We have proposed an amendment to clause 2.4. But on the issue of the fact that principals, caregivers, traditional surgeons, traditional health practitioners must be at least 40 years old, it is important to note that before the bill was tabled in Parliament, in other words, when the bill was drafted initially and consulted on with stakeholders before it went to Cabinet for approval to take it to Parliament, the age that we had there was 25 years old. Stakeholders during consultation processes raised a serious concern with this, and they said that people of the age of between 25 and 40 will not have sufficient experience to deal with this massive responsibility of conducting initiation schools. I also quote, there's a quote there of what one of the stakeholders actually said, where this particular stakeholders institution said that the surgeon, the principal, the caregiver should be equals to the age of the parents. I can also just point out that this matter was discussed at an initiation in Daba that was held and hosted by the former minister in 2013, where it was also at that stage agreed that more maturity is needed. And then when the bill was processed by Cabinet, in the Cabinet Committee, they also directed that the age limit should be 40. In fact, during consultations, there were even stakeholders who said that the age of 40 is not sufficient. It should be higher, much higher. But we've settled on 40 as the general acceptable one by stakeholders. So that particular amendment we do not support, but the next one, as I said, indicated we are supporting the issue of 10 years. Then the province in item 7, they are proposing that only people who have completed grade 12 should be attending initiation school. Now, we know in practice that this is not the case. What is also uncertain is there was no motivation really given by the province why they make this proposal. But we can only assume that they are maybe concerned that initiation may interfere with official school terms And in that instance, Honorable Chair and members, clause 27 of the bill states very clearly that initiation schools may not operate during official school terms. In other words, the rights of children to attend official schools are already protected, and therefore we say there is no amendment needed. Then item 8, the province makes a comment to say that the curriculum of an initiation school should not be disclosed. In this regard, Honorable Chair, it's very important to note that although the curriculum of a school must be submitted to the Honorable Chair, I hear somebody speaking.
I'm not sure who is Johnson. Can you please mute your mic?
Thank you, Chair. In this case, it is very important to note that although the curriculum must be submitted to the Provincial Initiation Coordinating Committees.
Sorry about that. Johnson, can you please? Mr. Johnson, can you please put your mic on mute? Otherwise, I'll request the host to remove you. Okay, Mr.
Chairperson, we cannot wait for Johnson when he's playing with children. Can't you switch Johnson out of this meeting, please?
Yeah, we've addressed it. Mr. Bester, please continue.
Thank you, Chair. So it's important to note in this case that the bill clearly states that any practice which is secret and sacred does not have to be disclosed as part of the curriculum. We do not want to interfere with customs. So all that this bill is saying is that the reason why the curriculum in general must be presented without those secret and sacred practices is for the Provincial Initiation Coordinating Committee to be ensured that there will be no illegal practices that form part of it. So we believe there is no amendment needed in this regard as the bill sufficiently deals with it. Item 9, Honorable Chair, and here as a department, we do not have a final proposal. In fact, we are asking the committee to assist. The province is saying that under no circumstances should alcohol be used at initiation schools. Now, clause 30 of the bill allows for alcohol to be used only as part of a religious sacrament and only in respect of the initiates to whom such a sacrament applies. On the one hand, the bill therefore protects the rights of the relevant initiates to practice their religious sacraments. It's also important to note that the bill clearly states that if that is done at an initiation school, it may only be done as provided for in section 10.2 of the Liquor Act. And I also quote section 10.2 there for honorable members to see. It states that the parent, adult, guardian of a minor or a person responsible for administering the religious sacrament must supervise that particular use of alcohol. So there is protection. Clause 34 also has protection against the abuse of alcohol at an initiation school. And important to note is that the offences clause, which is clause 33.6, states also that it will be an offence if alcohol is allowed at a school other than for the purposes referred to in section 10 of the Liquor Act. So from the department side, we believe that it may not be necessary to amend this particular clause, but if the select committee is of the opinion that there should rather be a total ban on alcohol at initiation schools, then we will gladly include that in the C list, Honorable Chair. Then item 10, the provincial legislature refers to or makes a comment there to say that it should be an offence to open an initiation school at the townships. We are not sure why they are proposing this. There's no motivation, but it's important to note that the requirements of the bill for the registration of initiation schools and the criteria that the schools must comply with apply irrespective of where the particular school is located or held. So whether it's in a township or in a rural area or in a city, the requirements stay the same. Therefore, we believe that it's not necessary to make any amendments to the bill in this regard, Chair. Chair, then we move to Gauteng, item 11. The legislature is saying that the department, not sure which department they refer to, but the department should ensure that principals and teachers are competent to perform a circumcision ritual. Now, principals and teachers have a role maybe in circumcision, but it's actually performed by the medical practitioners or the traditional health practitioners. The bill is very clear that principals and everyone else that are involved in initiation must be screened in accordance with criteria that must be developed by the National House of Traditional Leaders. And the whole purpose of such screening is to ensure that those people who are involved in initiation, whichever aspect of initiation, that they do have the expertise and they are capable to perform their tasks and their duties as provided for in the bill. So we believe there is no need for an amendment on this in this regard, Chair. Item 12, and if you allow, I will deal with item 12 and item 14 at the same time. They basically deal with the same thing. Item 12 says the department should ensure that commercialization of initiation school is prohibited, while item 14 says that initiation fees should be affordable and regulated. Now, both these comments are already addressed in the bill. The bill requires that initiation schools must be registered, and the bill criminalizes the holding of unregistered initiation schools. Therefore, it should do away with those instances where initiation schools are held purely for financial gain. And then important is clause 18.3 of the bill, Honourable Chair, that says that the minister may determine the fees to be paid by initiates for attending an initiation school. This is to ensure uniformity, but also to make sure that reasonable fees are put in place. Important to note that these fees must be published in the Gazette for public comment, and also the minister must consult all premiers, the National House and all provincial houses before determining such fees. We therefore believe that there's no need to amend the bill because these concerns are addressed. Then, Chair, item 13, the province is asking that strict measures are put in place to protect initiates from being abused. Now, as a general comment, the bill in clause 2, sub 2, states that one of the objectives of the bill is to prevent the abuse of initiates. And then clause 29 states that no initiate may be abused, while there's an offence clause in clause 33 that deals with the possible abuse of initiates and possible sentencing offences in that regard. But this matter was also raised, the issue of abuse was raised by a couple of provinces, and the first one that we received where it was raised was the Western Cape, and we will see when we get to the Western Cape inputs that we are proposing a specific way of addressing it. Then 14 I've dealt with. Then 15, the province is proposing that the rights of disabled people should be catered for. We support this particular proposal, Honourable Chair. We already state in clause 2.7 of the bill that no initiate may be discriminated against on grounds of disability. There's other provisions that deals with disability issues within the bill, but we are proposing, based on the input from the province, that clause 21.10 be amended to include the provision of sign language practitioners and braille services where applicable, as proposed by the province. We therefore support it. Item 16, the province requesting that adequately capacitated staff should be appointed to provide technical support to the provincial initiation coordinating committees. This is already covered by clause 17 of the bill. Clause 17 determines that administrative and financial support, not only through the PICC, but also the technical support teams, must be provided for by the provincial departments as determined by the Premier after consultation with MECs. And then furthermore, the clause determines that the HODs must designate officials from their departments, in other words, relevant officials, to provide the specific administrative support to the PICCs and the technical support team. Then KwaZulu-Natal, Honourable Chair. KwaZulu-Natal is one of the provinces where they drafted very specific amendments which were really very helpful. I'll go through them very quickly because we are supporting the majority of them. Firstly, item 17, the province is proposing that there should be one more member on the National Initiation Oversight Committee, the NEOC. One more member of the National House should be part of that, and we are supporting that. Item 18, Chair, the province says that the referral to the Department of Women should be amended to say women, youth, and persons with disabilities. This is correct. It's more technical, but we are supporting it. The thing is, when the bill was tabled in Parliament in 2018, at that time, it was still referred to as the Department of Women, but obviously after the elections in 2019, the new departments were created and the name has changed. So we are supporting that. They're also proposing that a senior official from the Department of Arts and Culture should become part of the National Initiation Oversight Committee, and we are supporting that, Honourable Chair. We have listed there on the right-hand side under item 19 how we propose that can be included. And just to note, it will also require some consequential amendments to be made to other clauses where it concerns cross-referencing. Item 20, this is about the first meeting of the National Initiation Oversight Committee, and they are proposing that the Minister or the Director General must convene such a meeting. We are supporting that, and we are proposing that clause 5.1 be changed as it appears there on the right-hand side, so that the Minister or the DG, if so directed by the Minister, can convene and chair the first meeting. Then item 21 is about technical support teams. And what the province is saying here, which I think is maybe just a misunderstanding of the clause, the clause currently, subclause 1A, refers to traditional leadership councils. And they are proposing that we remove that wording and replace it with traditional councils. But the introductory part of that clause, Honourable Chair, says that the traditional leadership councils that we are referring to are those ones, and institutions that we are referring to are those ones that are set out in subparagraphs 1 to 11 of that particular clause. And if you look at those, then subparagraph 7, Roman 7, clearly indicates that it refers to kingship councils, queenship councils, principal traditional councils, or traditional councils, as the case may be. There is therefore no uncertainty as to which structures the clause refers to, and we believe no amendment is needed. Item 22, the province, this is about medical practitioners, and the province is proposing that when a medical practitioner performs circumcision, it must only be for a particular male, is the wording that they are using. We agree that that should be included. However, they also raise an issue about consent in that clause 24.2a be amended to include consent. But this is not necessary, Honourable Chair, because subclause 1 already states that a medical practitioner may only perform circumcision, not only the medical practitioner. In fact, any person who is performing circumcision may only do so if all the consent requirements of the clause 28 of the bill have been complied with. But as far as the issue of a particular male is concerned, we are supporting that, and we are just having slightly different wording to say that if you look at the middle there of 2A, invite a male medical practitioner to perform circumcision on the relevant male initiate. In other words, the one that was specifically assigned to this medical practitioner. Then item 23, Honourable Chair. Here the province refers to written consent that is needed in terms of the Children's Act regulations, regulations 5 in particular. Now, regulation 5 does not deal with consent for initiation, but only for consent for circumcision. While this particular clause, 28.3, deals with consent to undergo initiation and not circumcision. Clause 28.6 deals comprehensively with the consent for circumcision, and it already includes a reference to Regulation 5 of the children's regulations. So the proposal by the province or the comment is already covered under clause 28.6, and therefore no amendment is needed, Chair. Item 24, the province is proposing that in the case of the death of initiate, the parents or the legal or customary guardian also receive counseling. We are supporting this just with a little bit of different wording as appears there on the right-hand side in the column. Then item 25, Honorable Chair, the province is proposing that the National House should monitor the implementation of the Act. Now, clause 36 of the bill deals with the overall monitoring responsibilities of the national and provincial governments through their respective departments. We must remember that monitoring the administration of the Act will fall with the National Department and the implementation will be with provinces. Therefore, government will have a responsibility of monitoring the implementation of the Act. Furthermore, there are specific kinds of monitoring duties that are assigned to the National Committee as well as the PICCs, and the clauses that are relevant are listed there for the benefit of the honourable members. Now, the National House, on the other hand, will have very specific duties and responsibilities assigned to them in terms of clause 19 of the bill, which does not include a monitoring function, because that will be the responsibility of government. However, we must remember that the National House of Traditional Leaders, as well as the Provincial Houses of Traditional Leaders, will be represented on this National Initiation Oversight Committee and the PICCs. In other words, they will be part of those structures where those structures perform the monitoring duties assigned to them in the bill. So there's no specific amendment needed here. Honourable Chair, then we move to Limpopo, item 26. Now, the very first comment there under item 26 by Limpopo is not for the DTA, for the department to comment on. It's just a statement made by the province that apparently some of the stakeholders were of the view that there was limited participation when they conducted public hearings. So the department cannot comment on that. Item 27, the province mentions that the terms customary and customary practices should be defined in the bill. Now, customs and customary practices, and we looked at a couple of pieces of legislation to see whether it's defined anywhere else. And it's hardly ever defined. I think if you read the bill, the whole bill, including what I quote there on the next page from the preamble, it is very clear what this bill is dealing with, which customs, which customary practices the bill is dealing with. It's clear when you read the bill, it deals with the initiation of traditional communities and traditional leadership and not any other form of initiation. So we believe the bill is very clear and that no amendment is needed. Then item 28, Chair. Here the province refers to the fact that the child who undergoes initiation should also agree or assent to such initiation. This is already in clause 28.3a of the bill, and I quote it there, where it says that a child between the ages of 16 and 18 may not attend this initiation school unless such child and his or her parents have given written consent. So that it's already required by the bill and no amendment is needed. Clause 20 or item 29 deals with medical practitioners, and it says that in the case of a while the bill requires that principals, caregivers, and everybody else must be people who have already undergone initiation, there's no such requirement for medical practitioners. Now, Chair, the bill, as it was tabled in Parliament, did have this particular requirement. However, during the COGTA Portfolio Committee, public consultations and their in-depth deliberations on this bill, they removed this requirement, but only as far as it concerns medical practitioners. And one of the reasons, therefore, was that the involvement of a medical practitioner in initiation will be limited basically to male circumcision. In other words, the medical practitioner will not be present during other rituals or practices. Other rituals and practices will be guarded by your caregivers, your principals, and your traditional health practitioners or traditional surgeons, who are people that must have undergone initiation. So we are saying that no amendment is needed in this case. Item 30 deals with issues of violence and sexual abuse. Now, Chair, this was something that was raised by the Western Cape when we received their inputs, and we're actually supporting this particular proposal, but we will deal with it in more detail when we get to the Western Cape. Then item 31, and there's another province who raised this particular issue, Chair, which is again, in our view, maybe just a misread of the legislation or not connecting the dots between certain clauses. Now, clause 6 of the bill contains certain disqualifications. In other words, a person who serves on the National Initiation Oversight Committee, and then another clause deals with the Provincial Initiation Oversight Committee or coordination committees, that there's a disqualification that says they may not serve on these committees if they were sentenced to imprisonment for a period of more than 12 months without the option of a fine. Now, what the province is saying is a person who was found guilty of sexual abuse, for example, should not be part of this particular structures. And in fact, this is covered by clause 2 sub 5 of the bill. This clause 2.5 clearly states that a person was found to be unsuitable to work with children in terms of the Children's Act, or whose name is listed in the National Child Protection Register or in the National Register for Sex Offenders, may not serve in any of these structures. In fact, such a person may not even be a principal or a caregiver or anything else. So it is covered under section 2, subsection 5. Then item 32, Chair. The province is saying that anything that is sacred, the bill must ensure that the rights of a culture must be consistent with the Bill of Rights. Now, this concern is addressed already in clause 3 of the bill that contains guiding principles, and it states that the customary practice of initiation is subject to the Constitution and must be transformed and adapted so as to comply with the principles contained in the Bill of Rights. Also, clause 2 sub 2 that contains the main objectives of the bill talks about the protection of life of initiates, prevention of injuries, etc., which is all aimed at making sure that it is consistent with the Bill of Rights. And let's not forget, there's clause 33 with the offences clause, which has quite some severe penalties in some instances. Then item 33, the province is saying that whatever is secret in the curriculum should not be made public. I think we've already dealt with this earlier under the Free State inputs, where we said that no secret and sacred practices have to be disclosed by the principal when he or she submits the curriculum. So no amendment is needed. Then item 34, the province is proposing that emergency services should be defined in the bill, and we fully agree with that. We realized after receiving the comments from the province that the bill is not clear on what exactly emergency services are. We have therefore defined it, but not under clause 11 as proposed by the province, but under the definition clause, which is clause 1. The definition is there for honorable members to look at, and yes, we support that particular one. Then item 35, the province is referring to the fact that the NIOC and the PICC should include members of the judiciary and education sector. We think it's maybe just a typing error or a misunderstanding of the terminology, because judiciary refers to judges collectively. We believe that what the province was aiming at are the line functionaries who are responsible for the administration of justice. And this is already covered in the bill. In the case of the NIOC, there will be representatives from the NPA and SAPS on this particular structure. And then in the case of the technical support teams that will be assisting the provincial coordinating committees, it also makes provision for SAPS, the NPA, Basic Education and Justice Department. So no amendment needed. Item 36, the province is of the view that the sentence of 15 years for holding of illegal schools is too harsh. Now, The issue of sentence of 15 years, I think it's important to note that that is a maximum sentence, and therefore a court can decide on a much lower term of imprisonment, and also the court can decide on an option of a fine without imprisonment. But very important, Honourable Chair and members, the whole purpose of this offence clause is to serve as a deterrent for those people who are conducting illegal initiation schools, who are abusing initiates, and who are getting away with it. There's an increase in recent years of what we refer to as illegal initiation schools. And that's one of the reasons why national legislation became necessary. So in our view, it is very important that the sentences, or in this particular case, the sentence of 15 years should be retained. And we believe that therefore no amendment is needed. Then item 37, this talks about misconduct by initiates and corrective measures to be taken. Now, this is already addressed in the bill. Clause 19.2 of the bill determines that the National House of Traditional Leaders must develop acceptable standards relating to discipline at initiation schools. The bill also states that misconduct must be dealt with preferably in accordance with the customs of a particular community. But very important is clause 29.1c that says an initiate may under no circumstances be abused or assaulted under the guise of discipline. And then just again, on the issue of abuse in general, when we get to the Western Cape comments, Honourable Chair, we have dealt with the proposals of several provinces on how to address the issue of abuse more effectively. Then Mpumalanga, item 38, they made one proposal, which is that no child or any other person may be forced or coerced to undergo virginity testing. We are agreeing with that. Western Cape made the same comment. We are supporting that, and we will see the proposed amendment under the Western Cape inputs. The Northern Cape did not propose any amendments. They support the bill as it is, and the same with the Northwest Legislature. Then Western Cape, Honourable Chair, item 1. Here, the province is raising two issues. Item 41. They're raising two issues. They're talking about a definition for surgical equipment. And then they say that there should be a definition for female genital mutilation. Now, we are not sure why they are proposing a definition for surgical equipment, because nowhere in the bill is the term used. Then as far as genital mutilation is concerned, the definition that we have in the bill is an exact duplication of the definition as it appears in the Children's Act. In other words, the bill is perfectly aligned with the Children's Act. So we believe no amendment is needed. Item 42, the province is proposing that emergency medical services should be taken into account, or rather the access to initiation sites by emergency medical services. We agree with that, Chair. We support it. And we are proposing that clause 15.1e of the bill be amended to include accessibility of the schools as one of the criteria that will be considered by the PICCs. Then clause 43, or item 43, the province says the bill should refer to the recognition of statutory Khoisan leaders in communities. Now, this particular proposal, maybe the province had something in mind that we are not quite aware of, but this bill does not deal with recognition of communities. The recognition of Khoisan communities and leaders is addressed in the Traditional and Khoisan Leadership Act. In short, everybody talks about the TKLA, and Honourable Deputy Minister Papela referred to it earlier. That act was published in the Government Gazette on 28 November 2019 as Act 3 of 2019, and hopefully it will very soon commence. It deals with the recognition of Khoisan communities, Khoisan leaders, and the establishment of Khoisan structures in detail. Therefore, this bill cannot deal with that. Item 44. Here the province is referring to the National Environmental Health Norms and Standards for Premises. This was a very useful comment by the province. We had, I remember during drafting stages of the bill, we did look at these standards, but we looked at them again. They were published in the Gazette in 2015 under a general notice. Now, Annex A of these standards contains the standards for premises, and in particular, clause 9 thereof deals with the standards for initiation schools. It deals with matters such as structural facilities, admission to for initiation, entry to initiation schools, water supply, sanitation, medical care, management of waste, etc. Now, I'm sure honourable members, when they've read the bill, would have noticed that most of these issues raised in clause 9 of Annex A of the standards are already dealt with in the bill, in various clauses of the bill. In fact, I actually found some of them that may even be in contradicting with the principles contained in the bill. But we do take this very serious proposal as a serious proposal by the province, and as a possible gap in the bill that we have not maybe dealt with before or addressed. And therefore, we are proposing that two things happen with the bill. Firstly, that a new definition be included under section 1 to refer to the standards for initiation school premises, by referring then in that definition to the ones that have been published by the National Department of Health, but also a proposal to amend clause 15 to say that when the PICC develop criteria that the initiation school must comply with, that they take into account the standards for initiation school premises, insofar as that such standards are not inconsistent with the Act or the bill or the Act when it becomes law. So we are actually supporting that particular one. Item 45, the province is saying that the age-specific references in the bill must be rechecked. We are not 100% sure what they meant by that, but all I can say is that the bill is aligned with the Children's Act. As we mentioned earlier, it talks about children between 16 and 18, and then adults older than 18. So it's aligned with the Children's Act, and we are not proposing any amendment in this case. Item 46, two issues that the province are dealing with here. They refer to relevant tests that must be concluded before a medical certificate is issued. And they say that the bill should also address the confidentiality measures regarding the medical certificate. Now, on the first issue about tests, it is not clear which tests the province is referring to, but the bill deals very, very comprehensively with the issuing of medical certificates in quite a number of clauses. And obviously, for a person to obtain a medical certificate, whichever tests he or she must undergo will have to happen before the medical certificate can be issued. The matter regarding confidentiality, we are fully supporting that. We are proposing that clause 2 of the bill be amended to include a new sub-clause 8, which then reads as follows, as it stands there, that every initiate has the right to confidentiality regarding his or her health status, that the medical certificate that will be issued must be regarded as confidential by everybody who must receive it, as well as the person issuing it. But then importantly, Chair, we are saying in the proposed paragraph C that notwithstanding the above, the confidential status of a medical certificate may not be used as a reason for non-compliance with, in particular, section 22, 1C to F or 2 of the bill. That section 22 is the one that deals with the disclosure in the medical certificate of, for example, serious health issues like heart problems, breathing problems, etc. So the certificate will have to disclose that, otherwise the principal of a school and the caregiver will not know what treatment to apply to a particular initiate. Then item 47, here the province is referring to medical certificates. They are concerned that you have cases where a medical certificate is issued in a province other than the province where the initiation school is held. So we are supporting the proposal that this be addressed, and we are saying that section 22(1)(c) can be amended to stipulate that the certificate from a medical practitioner must come from a person who's practicing in the province where the initiation school is to be held. Item 48, they are proposing that the bill should contain a definition for virginity testing, and also what was raised earlier by other provinces, that it should state that no person may be forced or coerced to undergo virginity testing. Now, Chair, on the first issue of a definition for virginity testing, the Children's Act does not have a definition for virginity testing. But the clause 28 of the bill that deals with this is basically an exact duplication of what is contained in the Children's Act. So we are reaffirming what the Children's Act is saying, and we believe there's no amendment needed. But on the second matter, we are agreeing, and we are proposing that particular clause be amended to indicate clearly that no child or other person may be forced or coerced to undergo virginity testing. Then item 49, this is the one about abuse that I've mentioned a couple of times, that will address quite a number of concerns raised by provinces. We looked at, there is currently no definition for abuse in the bill. It does refer to abuse on numerous occasions, and it's not limited anywhere, except we found that in clause 2.2 of the bill and in the offences clause, it refers to physical and mental abuse. So what we are proposing, Honourable Chair, is that we insert the definition for abuse to say abuse includes, but is not limited to physical or mental abuse, sexual abuse, any form of gender-based violence, and any harmful practice that the initiate may be subjected to. So therefore, if that is agreed to bring in that definition, we will have to make some consequential amendments to 22B and 33.6, just to remove that reference to physical and mental abuse so that it covers all kinds of abuse. So we support this particular amendment. Item 50, the province is referring to the fact that there are specific timeframes within which the National Initiation Oversight Committee must submit their reports, 6 monthly reports to the Minister, and also that such reports must be submitted to the Premiers, MECs, and the PICCs within specific timeframes once the Minister approved the reports. They are asking that the timeframe be included for the Minister to actually deal with these reports. In our view, it may be impractical to include such a specific provision, especially taking into account the nature of the reports, where it may not include massive decision-making that is required, but it's merely a report from the NIOC to say, this is what we have done in the past 6 months. So we believe that the bill is, there's no need to amend the bill in this regard. Item 51, they are proposing that the bill should make provision for community-based initiation structures. Now, this is already covered for in the bill in clause 39 in our view. The bill makes provision for structures at national and provincial level, but also for local initiation structures, as well as the involvement of municipalities. What the bill says, being an enabling piece of legislation in this regard, is it says that provincial legislation may provide for the establishment of local initiation structures. And that may include then community-based structures if the province so decides. So there's an enabling provision in our bill, and therefore we do not need to include the community-based structures as such. Item 52, the bill should strike a balance regarding the intersection between LGBTI persons and tradition. Well, we are supporting this, and what we are saying in our proposal is that clause 2, subclause 7 of the bill should be amended to state that you may not discriminate directly or indirectly against any initiate on the grounds of disability, which is already in the bill, and then we're adding on the grounds of gender or sexual orientation. So we support this particular one. Then clause item 53, it deals with that issue of sexual offences for more than 12 months. I've referred to it earlier, where I explained that it is covered by clause 2, 5, and 6J of the bill. So I'm not going to repeat it again, Honourable Chair. Then item 54, What the province is proposing is that the awareness campaigns that may be conducted by these structures should include sexual orientation, gender identity, and sexual offences. Now, the bill says that the NIOC and the PICCs must conduct initiation awareness campaigns. And it also says that this should be focused on the rights and the responsibilities of initiates and other role players. So there's no limit in the bill as to what the awareness campaigns should consist of. But the focus is definitely on the rights of initiates. Therefore, it will include the aspects referred to by the province. And in our view, we do not need to amend the bill at all for this purpose. They also mention, as a last comment from their side, that female healthcare practitioners in female initiation schools is needed. Now, we believe this is something that customs are taking care of in any event, because when you have female initiation schools, the principals are females, the healthcare practitioners are females, the caregivers are females. You will not find a male there, because in terms of customs, it is not allowed. Then, Chair, lastly, when this bill was tabled in Parliament, I'm now at the one that says Department of Traditional Affairs, DTA, proposed amendments. I'm not going to go through the right-hand column. I'll just explain what this is about. When this bill was tabled in Parliament, the Traditional and Khoisan Leadership Act was not yet finalized by Parliament. However, since then, as we mentioned earlier, it was published in the Gazette. Now, this bill in front of the House has certain definitions that refer to the Traditional Leadership and Governance Framework Act, the so-called Framework Act. This Framework Act will be repealed by the Traditional Khoisan Leadership Act when it commences. So what we've done, it only concerns a few definitions. What we have done is to propose that we insert a definition in this bill for TKLA, that means the Traditional Khoisan Leadership Act, and that we amend those relevant definitions in clause 1 to refer to the current situation, but also the new definitions that will come. So that when the TKLA commences, there's no need for Parliament to reconsider and make any amendments to this particular bill just purely because of outdated definitions. Honourable Chair and honourable members, thank you very much. That is the Department of Traditional Affairs views on the negotiating mandates. And as indicated, we are supporting quite a large number of them. We believe they improve the bill, will improve the bill. And we have already drafted the C list based on these proposals. And then may I just refresh, Honourable Chair, your memory is the one that we do need guidance from the committee is the one about whether there should be a total ban on alcohol or not. Thank you, Honourable Chair.
Thank you, Mr. Bester. I think there are quite a few amendments that the department is supporting. I know your list is on another page, but okay, I think you've mentioned item 9, but I think before we're going to go into discussions, I'll request the parliamentary legal advisor, Phumelele Ngema. Ms. Ngema, if you could maybe provide your views on what was presented and any other view that you may have on the proposed amendments for provinces. Phumelele? Phumelele, are you with us?
Thank you, Chairperson. I'm here. I was trying to find these technical IT things. Chairperson, thank you once again and greetings to all the members. We appreciate this time and having to go through the mandates as the department has presented their responses. Chairperson, the fortunate part is that when we got the mandates, we started engaging together with the department. So we've been working hand in hand on what has been proposed, and the C list is an ongoing process that we are engaging on. Basically, Chairperson, I don't have any objections or any concerns that I need to raise in respect of what has been presented before the committee. It is just to confirm, Chairperson, that once we finalize the proposed amendments into a series, there's going to be amendments as already presented in clause 1, clause 2, clause 4, clause 5, clause 15, clause 21, clause 22, clause 24, clause 28, and clause 30, clause 31, and clause 32, Chairperson, together with clause 33. And most of these are consequential amendments, which mainly will be speaking to what has already been explained in terms of the enacted Traditional and Khoisan Leadership Act, but is not yet put into implementation by giving us a commencement date, which is the only outstanding part, which is why during the processes of this committee and before the National Council of Provinces, we thought it's prudent that such amendments be made, seeing clearly that that is now already legislation, even though it has not commenced. So, Chairperson, what we will do are the quality controls and confirmation that everything is properly referenced, should the committee be indicating that the proposed amendments, as explained and as already drafted as a draft, should be prepared into a C list, Chairperson. That is basically all that I need to say, but I'm in support of all that has been explained in terms of policy and the changes and what the department is accepting. Thank you, Chair.
Thank you, Kumalele. Honourable members, I'm going to open it up for discussion or comments from yourselves. But also, if you can also, if you have a view in terms of what was raised in item 9 with regard to whether there should be a total ban on alcohol initiation schools. I think, as has been explained, that section 10 subsection 2 of the Liquor Act does have certain requirements where the parent, adult guardian of a minor, or a person responsible for administering a religious sacrament may on occasion supply to that minor a moderate quantity of liquor to be consumed by the minor in the presence and under the supervision of that parent, guardian, or other person. So that is also a matter that the department also asked for guidance from ourselves. On that, let me open it up for discussion. Is there anyone who would want to speak? You may raise your hand, you may shout all at once. Remember this? The chair did join us for a while. Unfortunately, he left us again. I think he had a signal and or battery power. As members, I don't think there's any issue we would want to raise. I think that you comfortable with the explanations that have been given. I think in terms of item 9, what the department had indicated was that there were of the view that it was not necessary to amend the clause. And I think that all members are agreed to that view. I just wanted to just have one additional suggestion just to make to the team that goes back and look at Honorable Apiri, I see your hand is up. Honorable Apiri.
Thanks very much, Chairperson. I wanted to speak on this matter of that the initiation school can be put anywhere. I have a fear, Chair, that if we leave it like that, remember the initiation in its nature is a private and secret matter. If we just leave it like saying it can be put anywhere, we might at some point find it in the back room of someone, and it will it will lose its nature of being a a private and secret school. I'm not just sure as to how can we put it, but if we leave it open like that to see it can be anywhere, I have that fear, Chair. Thanks.
Thank you, Honorable Kiri. Any other member with any issue? Okay. I'm going to ask the department to respond to that, but the issue I also want to raise for the department is parliamentary legal advisor, especially in terms of amendments that relate to the Traditional Christian Leadership Act. We're not sure when the Constitution will be going to be effective in this piece of legislation. Yeah, maybe then let me hand over to the department. Oh, I see. Honorable Matsamai. And followed by Honorable Seleku. Honorable Matsamai.
Ke a leboga Chairperson. Mo Gauteng ke ile ra bua ka yone yone pele ena ya setso. Re shebile gore batho ba rona ga bana lefatshe. Batho ba rona tshwanetse ba thole lefatshe gore re ka se tloele fela ya ka eme. Go sena one matla gore batho ba rona ba kry lefatshe la gore ga ba sebedisa setso le ga ba se sebedisa go ka ba kae a ba nne le lefatshe ba se ka o sebedisa mo polaseng ya motho ka morago go utlwa gore ga go sa tlhole go na le lebollo mo batho ba ntshitswe monga polase ga ba batle a go be le ditulo tse e leng gore batho ba rona ba tla ba le tsone thata ba fie lefatshe. Ke a leboga Chairperson.
Thank you, Honorable Matsamai. I hope Mr. Bester from your team, there's someone who understood Honorable Matsamai's comment. Ordinarily, the Chairperson, Honorable Dodo, would translate. However, yeah, if you haven't got the comment, then please you just indicate that you have not. Can I get Honorable Seleku?
Good afternoon, Chair. Can you hear me?
Yes.
Yeah, Chair, I think one of the things that has been raised and correspondence sent to you as a chairperson was the issue of face interaction with some of the doctors that actually perform the initiation when we have these initiation schools. But due to COVID-19, we were not able to fulfill that role. And some of the questions in terms of alcohol would have maybe been better dealt if they had been given an opportunity to actually engage in terms of alcohol, when is alcohol needed, why do we need alcohol, can we actually ban alcohol in totality? Because we need to understand that this initiation is a cultural thing, and it deals with different cultures, and there are certain things that needs to be done. There are certain things that actually goes with initiation, and because it's tradition. So I would have loved if there was that interaction, when you talk to these surgeons and these makangatas, and then, to get the views from them. But unfortunately, we're restricted with COVID-19. Chair, also in terms of just a clarity-seeking question, when we talk about grade 12, I just need to understand if grade 12 is a requirement for young people to go to initiation school. Because if we're going to say that grade 12 should be a criteria, then we're actually saying all initiates are actually attending school. So, and the age, the Children's Act gives us actually the age group that says from 16 you can be allowed to actually attend, you go to initiation school. So the issue where grade 12 comes in, I just need someone just to clarify for me, because anyone, you don't need to belong to go to school to need to go to initiation school. Thank you very much. Just need to clarify on that one.
Thank you. Honorable Bartlett. Honorable Bartlett, I see your hand.
Yes. Sure, I just want to find out clarity on the issue of, I didn't hear that properly when it said they can give somebody a fine but not imprisonment. I just want clarity on that clause because I couldn't follow it properly.
Thank you. Thank you, honourable members. Mr. Desta, are you going to respond? Did you understand the comment by Honourable Matsamai?
Honourable Chair, thank you. I will respond to some of these. I think Honourable Deputy Minister Bapela may want to respond to some of the issues perhaps, and also the Director General, Mr. Dipova. I request that they go first.
Okay, Deputy Minister, do you want to start? Deputy Minister? But perhaps, Deputy Minister, you can round off. Mr. Dipova.
Thank you, Honorable Chair. I hope I'm audible now.
Yes, you are. You were not earlier, even if you addressed us and we didn't hear what you said.
Yes. No, thank you. There was a problem with the gadget here. I think maybe just to deal with the issue raised by Honorable Motsamai, because the issue is about land and making land available for purposes of customary initiation. The bill does not deal with that specifically at the moment, because we take it that this is a matter that happens by and large in areas under the jurisdiction of traditional leaders, and where there is land as a matter of course, which is under the jurisdiction of traditional leaders. So I think when it comes to particularly availing land, the bill does not deal with that because of that assumption. However, I think where it becomes then particularly tricky is where the issue of townships come into play, because you will then have a number of these townships which will fall directly under municipalities and not necessarily under the jurisdiction of traditional leaders. However, there are those that have made the argument that it is their right to practice this and to make sure that those who live in these areas also have areas where they can ensure that this culture is practiced. And I think it has therefore been difficult for us to come up with specific restrictions that say to them that you will not be able to practice cultural initiation in urban settings. But I think we stand advised by the committee on specific proposals that the committee might want to make in that regard. I thought I should just respond to this one that relates to the place and availing land where customary initiation can take place. But I'm sure that Dr. Pester will then be dealing with the other issues that have been raised in relation to grade 12, for example, and the other comments that the honorable members have raised. Thanks, Honorable Chair.
Thank you,
Honorable Chair and members. Just to add on also to what DG has already explained on the land issue. When members have time, they can look at clause 26, subclause 4 of the bill. There we deal with the issue of consent that must be given in the case, for example, of a private landowner, where that owner must give consent to the traditional leaders for the school or to the principal for the school to be held on his or her land. It also deals with the issue of land that falls within the area of jurisdiction of a traditional council and state land, and etc. So there is some form of protection there in clause 26, subclause 4. The issue of grade 12, no, honourable member, it is not a requirement in the bill that initiates must have grade 12. In fact, it is a proposal made by one of the provinces that grade 12 should be a requirement, but we are not supporting that proposal because we are saying that exactly as honourable member has pointed out, that in terms of the Children's Act, any person from 16 and up can undergo initiation, and that's also what this particular bill states clearly, that 16 and up. And that may not necessarily be people who have completed grade 12, but there is protection in the bill for the fact that the initiation season may not overlap or interfere with the official school terms. Then the issue of the fine or imprisonment. Honourable Member, that particular clause, offences clause, which is clause 33, makes provision for imprisonment, maximum sentences, or fines, or both. So they are all covered there. So a court will then obviously use its discretion to decide based on the severity of the particular transgression, whether it's only imprisonment or only a fine or even both. Honourable Chair, when you were speaking about something about the Khoisan, and unfortunately at that stage, I could not hear what you were saying. You were breaking up. If you don't mind repeating what you were asking.
I was just indicating that the TKLA bill or act, sorry, it hasn't commenced as yet, and we don't know when it will commence. Yet the amendments you're making is aligning it to that piece of legislation. So I just wanted your view on that, or if you don't comment on it, when you work together with people team on these issues, make sure you deal with that matter.
Okay, now I understand now. Thank you, Honourable Chair. Now, the way that we have drafted the amendments to the definitions is that they will apply with the current situation where the Framework Act is still applicable, and they will apply when the TKLA commences. For example, we will be saying a traditional council, the definition will read, for example, that a traditional council means the traditional council as contemplated in Section 3 of the Framework Act or Section 1 of the TKLA once it commences. So we're just covering both scenarios, Chair. Thank you.
So why don't you use applicable legislation rather? But anyway, can you guys deal with that matter as you prepare the syllabus? I don't want to have a title. Okay, are you done with it? Are you done?
Yes,
okay.
thank you.
Yeah, okay. No, that's fine. Do you want, I see the parliament leader and other would like to come in as well. Maybe I should just ask Pumelele. Pumelele, did you have a comment?
Thank you, Chairperson. Just one more thing, Chairperson. I thought I must add on the question of Honorable Mayor Apiri. The question that was pertaining to the restriction of the initiation schools and their location. I just want to supplement what Dr. Bester has already said, Chairperson. In light of what Clause 26 and Clause 15 is already providing in terms of the registration and all the requirements that are necessary, I think it is also imperative that we add the point that if we put a restriction in any manner other than as the bill is already doing, we might be finding ourselves flaunting and contradicting the provisions of the Constitution, which are basically granting everybody a right to exercise and live their cultural lifestyle, regardless of where they are at. So we are of the view that the manner that Clause 26 read with 15 is already providing for how to curtail and deal with such issues. That is sufficient, and it is constitutionally viable and aligns with the constitutional provisions, so that we are not found to hamper the rights that are found in the Bill of Rights in Chapter 2 of the Constitution, Chairperson. I thought I should just add that and provide a response in respect of that question. Thank you, Chair.
Thank you. I think we've covered all the issues except for the comment that was raised by Honorable Suleku around the issue of alcohol. I'm not sure if you still want to speak to it, Mr. Bester, or Mr. would you like to come in here?
Honourable Chair, if I may, In view of the department, as we state in that document, we believe that we should not infringe on the rights of initiates who are allowed to use alcohol for that particular purpose, which is a religious sacrament, and under the clear restrictions that are there in terms of Section 10 of the Liquor Act. In other words, as the bill currently reads, we believe it protects their rights to make use of it where necessary, but at the same time, the bill is very, very clear that there may not be any abuse of alcohol or any manufacturing of alcohol or anything like that at an initiation school. So in our view, we think that the bill is sufficient as it is at the moment, Chair. Thanks.
Thank you, Mr. Bester. Honourable members, do you have any follow-up? Or you sufficiently covered by the responses?
We covered.
Thank you, honourable members. Deputy Minister?
So thank you, Chairperson. I think all the points were responded to and sufficiently so. And I don't think there are any difficult ones. Yes, there has been, but I think they were able to, and explained. And I think the one that was the most difficult was the one of the LGBTQA plus, because the bill does not discriminate who comes into the initiation. So we don't look at their sexual orientation. Anyone who comes who feels that they want to participate in the culture do get allowed. It's only when the people are inside there, obviously, attitudes will always rise, but it's not because the bill is preventing. It will be the attitudinal elements that we hope that as we go along in the implementation of the bill, the traditional leaders will also have to play a role in ensuring that everybody understands that there are this sexual orientation that are now part of our society, that are protected in the Bill of Rights, and therefore their right to express should not be discriminating on those who want to practice culture, irrespective of their sexual orientation. Now, I know it's a very difficult issue, but it will then go belong alongside the education, awareness, and then also an understanding of a community now that needs to accept this new way of life and the people who believe in that. Thank you very much.
Thank you very much, Minister, and the officials from the Department of Traditional Affairs for all responses and explanations they provided to us. As a matter of procedure, we will then get these amendments based on what was presented to us, as well as the discussions that we had in our next meeting for adoption. I'm just proposing, I don't even know if there's a representative from the Office of the Chief, the State Law Advisor, present here as well. But anyway, but if the relevant legal teams can go up and deal with the CLS, looking into the various amendments that have been as well as all the consequential issues, as well as those in relation to those amendments, as well as the alignment issues in terms of aligning to other pieces of legislation. There have been quite a number of amendments that have been agreed to as raised by provinces, and perhaps rightly so. With that being said, honourable members, I think we've come to the end of the meeting. On behalf of the Chair, Honourable Bedovu, let me thank all of you members for your attendance and participation in this meeting. And I would like to then declare this meeting closed. Thank you very much.
Thank you very much, Chair.
Thank you, Chair.
Thanks, Chairperson.
Thank you very much, Chair. Sebonga.
Thank you.
Thank you, Chairperson.
Thank you, Chairperson.
Bye.
Sally.